Hello. This video provides a view of state hearings hearing process and the life cycle of a hearing. The process begins when a claimant wants to appeal an action by an agency regarding their social service benefit. Currently, state hearings hears general jurisdiction cases like CalFresh and CalWorks, Affordable Care Act cases, scope of benefit cases, children and family resource cases, and in-home support services cases. During this presentation, you'll hear the terms hearing request, appeal, and case, but they all mean pretty much the same thing. So how do these appeals get to state hearings? There are very many ways for a claimant, a representative, or an agency to submit a request to state hearings. The claimant can use postal mail or fax to send us a written request or send the county a written request, or they can use our two different online services. We have a public intake form and the ACMS e-filer account where they can submit their appeals online, or they can even make a phone call to state hearings and one of our friendly phone agents will help them file their appeal. Some appeals go through the county and the county sends them to state hearings using a secure file transfer, but I don't think that happens very much now. One of the first things that ACMS does is determine whether an expedite needs to be resolved. An expedite is when the claimant requests that a case gets heard quicker than normal. Usually this is because of a medical need. So when they submit their appeal request, they can ask for an expedited hearing and they need to provide a reason. And someone at state hearings, usually a presiding judge, sometimes staff can do this. They'll resolve that expedite request. They'll look at the reason that was put in by the claimant and determine whether the hearing needs to happen sooner than normal. Now, if they feel that the reason is a good reason to expedite the hearing, they'll grant that expedite. And what happens in ACMS when that expedite is granted is first a manual scheduling task gets created. The due date is going to be adjusted depending on what type of case it is. The review task gets generated and a granted expedite letter is generated. If the case request expedite gets denied, then the review task still gets generated and a letter explaining the denial also gets generated. So this expedite request doesn't have to happen when a claimant onlines a hearing request or first requests a hearing. They can request an expedite anytime before the actual hearing happens. So after that expedite is resolved, the next thing that happens is a review. So if somebody submits a hearing request and they did not request an expedite, it just goes right to review. And what happens during review is this case will go to our review team and they're going to look the appeal over and just make sure that all the information on the appeal makes sense and is accurate, and there are no duplicates, and the claimant is correct, and all of that information they do a double check and just make sure that all the information is filled out properly. Once they do that review and close that review task, an acknowledgement letter gets generated and a hearing request summary document gets put in the case in ACMS. Now about the automatically generated letters, there are two ways that a claimant can get those letters. It depends on what they put down for their communication preference. The two choices are postal or email. Now, when a claimant says they prefer to get everything by postal mail, ACMS takes care of mailing those out through the Office of State Printing. And if a claimant says they want to get their notices via email, the notices are not sent via email, but the ACMS sends an email notification to let them know that they can sign into their account on ACMS and take a look at the document in there. So once the review is done, the case goes into pending scheduling status, and that means that it's just waiting to get scheduled. Cases aren't scheduled right away because some agencies have negotiated a minimum wait time. For example, like Covered California, they require a minimum of 30 days before a case can be scheduled. This waiting time in pending scheduling between review and actually getting scheduled gives these agencies time to contact the claimant and perhaps negotiate some sort of resolution for their complaint. And that way, the case doesn't have to go to hearing. Then the cases eventually get scheduled if they're not resolved within that wait time. And there's two ways that cases are scheduled. They can be automatically scheduled through OptiPlanner, or they can be manually scheduled by one of our schedulers in state hearings. And once that's done, a notice of hearing document is generated. And that's the document that lets the claimant know that their hearing has been scheduled. It lets them know the date and the time and the modality of the hearing. So let's talk about modality. There's actually 5 different modalities. During the pandemic, though, the in-person modality, which is the first one that's listed, is not being used. We're not doing in-person hearings right now for safety reasons. Most of our hearings are done via phone or by video WebEx. So those are the other 2 modalities. We have in-person, phone, video, WebEx. The other 2 are very rare, on-site video and in-home modalities. The on-site video is a new video modality that we have, and this modality is for those claimants that don't have a computer, tablet, smartphone, or internet connection, but they still want a video hearing. So what they'll do is they'll go into their local county office and they can do a video hearing from there. Well, we haven't started this modality yet, but we do hope to have it started sometime in 2021. And that final modality is the in-home modality. This is very, very rare. Most hearings can be done by one of the other 4 modalities, so this in-home hearing is extremely rare, and there'll have to be very special circumstances for somebody to be granted that modality. Now, once the hearing is scheduled, it goes to an administrative law judge, ALJ, and several things can happen in ACMS. So the judge can postpone the hearing if for some reason the claimant contacts the judge and says, I can't make it for some reason. Or the judge may withdraw the hearing if the claimant says that they do not, they've changed their mind and they don't want a hearing. If the claimant doesn't show up at the appointed time, or doesn't answer their phone, or doesn't appear at the video hearing, then it becomes a non-appearance. Or if everything looks great, then the judge will start the hearing. Now, I'll talk a little more later about postponements and withdrawals. So once the hearing has started, the administrative law judge will sit there and talk to both the agency and the claimant, and maybe if the claimant has a representative, that representative, and any witnesses. And they will get the facts of the case, and they will either close the case, that's heard closed, or they may continue the case if they need more time, or they might hold the record open, and that's when the judge needs more information from one or both of the parties. Usually it's some sort of document they need to provide. And then again, there could be a non-appearance, postponement, or withdrawal. Now, all of those things that you see on the screen that have an asterisk, a letter is generated when the judge chooses those actions. All right, once the judge closes the hearing and the judge feels like there's enough information there for the judge to make a decision, then the judge will write the decision and upload the decision to ACMS. And there's two types that the judge can upload. They can do a proposed decision or a final decision. Now, a proposed decision goes through a review process. Sometimes this happens for judges who are new and they're going through their training, and they upload their decisions as proposed decisions where their mentor or a PJ, which is a presiding judge, reviews those decisions and can adopt them or change them or send them out for external review. Now, external review is when an agency has the authority to review those decisions before they are adopted. And the external agency can make any changes they need, or and that's called an alternated decision, or they can say, yes, that's great, go ahead and release it. Or if an agency waits too long, it'll automatically be adopted by operation of law, because we don't want those decisions sitting there forever waiting for the external agency to review it. And then the other type of decision that a judge can upload is called a final decision. And same with the proposed decisions, once it gets approved by the external agency, or these final decisions that are uploaded, the next step goes into quality assurance. And this is where the staff will take a look at that decision, just make sure that it's grammatically correct, that there are no spelling or obvious errors. They check for things like accessibility, make sure that the decision meets accessibility standards, and they also check to make sure that there's no personally identifying information, that's PII, on those decisions, because once that decision gets released, it also gets put into our decision registry. We have a registry of decisions that the public can search through and see what types of decisions have been released by state hearings. So once that's done, the QA, then the decision gets released. Now, it's very important, if you are a staff member that is tasked with this QA duty, once you hit the button to release that decision, there's no taking it back. So if you've discovered that there's some sort of an error, you would have to do probably a clerical error letter or something. But ACMS can help guide you through if you think you've released a decision that should not have been released. So, improper requesters. This is a term that may come up, and what it means is when there is a hearing request, the only person that can make that request is the recipient of that benefit. So if my mom or dad I wanted to make an appeal on behalf of them, I would be an improper requester, because it's their benefit and I'm not allowed to make that hearing request without their permission. Now, if I do have their permission to act on their behalf, then I become an authorized representative. But I need to have a form or something that tells state hearings that I'm an authorized representative for that person. So Sometimes we will get requests from somebody who is not the beneficiary, not the claimant, and we call that an improper requester. ACMS automatically takes care of that. So if they use the public intake or the ACMS online using an account, they use any of those ways, ACMS already checks for that, and it will mark it as an improper requester if they don't meet the right criteria. And then for those that come over the phone or that come to us in a written form, you would have to make sure that you've got a signature on the form. That makes it okay. Or if you're actually talking, if you're taking it over the phone, if you're talking to the actual claimant, that's fine. Otherwise, they'll need to provide you with an authorized representative form. And then there are some things that can serve as an authorized representative form, like perhaps I have a power of attorney that allows me to make these kind of decisions for another person. And that would serve as a document that proves I'm an authorized representative. Now, a parent for a minor or a foster parent, they're automatically authorized representatives for their children. And actually, they're usually the claimant, and the child is the beneficiary. So what happens if there is an improper requester? Well, ACMS actually marks the appeal case in ACMS as improper requester. There's a big red flag on the front. You can't miss it. And that stays on there. But the only other thing it changes is that it doesn't delay the hearing at all. This appeal will still go to hearing, and if that flag isn't resolved by the time the hearing comes around, then the judge is going to figure it out. The judge is going to say, hey, it says there's an improper requester here. Who's the claimant, who's the representative, and the judge will determine if that requester is actually an authorized representative. Now there are withdrawals. So once a claimant files an appeal with state hearings, they might change their mind, in which case they'll need to withdraw their request. And there's two kinds of withdrawals. There's a conditional withdrawal or an unconditional, also known as a straight withdrawal. So these withdrawals can also be verbal or written. They can call us up and say, hey, I want to withdraw my hearing. I don't want to do it anymore. Never mind. And we will, if we hear from the claimant, we will go ahead and withdraw that case. Now, the conditional withdrawal is when there are conditions happening. So let's say an agency and the claimant got together, and the agency said, hey, we'll do A, B, and C, and that should take care of you, and we don't need to go to hearing. And the claimant says, yeah, that sounds good. If you do A, B, and C, I won't need a hearing. So that's called a conditional withdrawal. So the claimant comes to us and says, you know, this agency said they're going to do A, B, and C, so I'm going to withdraw my hearing request. No matter what type of request it is, whether it's an unconditional or a conditional withdrawal, we need to get that verified by the claimant. So we need either a signature, an email, a phone call, something from the claimant saying they want to withdraw. If the agency tells us, hey, I talked to the claimant and the claimant says they want to withdraw, that's fine and dandy. We still need to hear it from the claimant. So we need some sort of form or signature verifying that they want to withdraw, because the hearing actually belongs to the claimant. So once a case gets scheduled, sometimes there's a postponement that's required, and there's two kinds there as well. There is the claimant or authorized representative requesting it, or maybe the agency requests it. So let's say you're a claimant and you've got a hearing coming up on a certain day, and then something happens and there's no way you're going to be able to make that hearing. What the claimant would do is either contact the agency or state hearings and say, I would like to postpone my hearing. And that request goes into ACMS. There's a task called a postponement task, and there's two kinds: the claimant AR or agency postponement. And it's very important to distinguish those two, and I'll tell you why in a second. If a claimant requests a postponement, that's fine. Sometimes an agency can't make that hearing time. When that happens, those are very rarely granted. So these postponement requests, remember these are always requests. If the claimant asks for it, it's still a request. We either grant or deny the postponement. Same thing with the agency. And usually, if it's the first time a claimant requests a postponement, we grant that automatically. No questions asked. That first one is like, all right, things happen. But if there are any subsequent postponements, the claimant should have good cause. It's probably a really safe thing to check very closely when you see a claimant postponing their hearing over and over and over again. There's probably some possibly nefarious reason that these postponements are coming in. So at that point, you usually get your presiding judge involved, and they would look at that. If you are a staff member tasked with resolving postponements, again, the first one's free, and then after that, you probably would just escalate it to a presiding judge. So the difference between a claimant requested postponement or an agency requested postponement is when the claimant requests a postponement, we get to add 30 days to the due date of the appeal. But if an agency requests it, we don't get to add those 30 days. Now, the due date of an appeal is really important. I think I'm going to be talking about that in, let me see here, in another slide. I'll be talking about why those due dates are important. So oftentimes those agency requested postponements are not granted. And either way, for any of those requests, a letter is going to get generated explaining why it was either granted or denied. All right, the next thing we're going to talk about is bifurcations and administrative dismissals. And you're going to see a task called bifurcation/admin dismissal. And agencies can request a bifurcation or dismissal when the agency feels that state hearings doesn't have either the authority to hear the case, or maybe too much time has lapsed, and the claimant doesn't have the authority to file an appeal because it's been a year or whatever the time is, or if the agency thinks that state hearings doesn't hear those kind of cases. So what they would do is they would open a bifurcation or admin dismissal task, and they would write in there why they think this appeal should be either bifurcated or dismissed. And these bifurcation dismissal requests are going to go to a presiding judge to decide. Sometimes a presiding judge may designate somebody to look at those and grant or deny those requests. Either way, a letter is going to get generated whether it is granted or denied. And also, when an agency makes one of these requests, they also need to send a letter to the claimant, letting the claimant know that they've made this request. So I talked about due dates when doing postponements, and why are those due dates important? Well, once a claimant files a hearing request, State Hearings has 90 days to resolve that request and have a decision. And if we don't meet that deadline of 90 days, then there are penalties that State Hearings pays. And those penalties can range anywhere from $20 to $75 a day, and it all depends on the type of case. So it's very important that we meet that deadline of the due date. So that is why having that postponement, the 30 days added to the due date for a claimant postponement is important. And then, of course, the administrative law judge may also adjust the due date because of things that happen during the hearing. They have that authority. So once a case is done and a hearing has come to its final conclusion of either a withdrawal or a dismissal or a decision, a claimant can request a reopening. Let's say they were a non-appearance. They can request that this case be reopened as long as they do it within a certain amount of time and they have good cause for reopening that request. And the other reason for reopening a hearing is if they withdrew their hearing request and then changed their mind and said, you know, I withdrew this hearing, but I've changed my mind. I want a hearing again. So that's called a reopen. But if a claimant has a decision and maybe they didn't agree with the outcome of the decision, then they can request a rehearing. So both these reopens and rehearings have a limited time frame, and letters get generated to the parties to let them know when that reopen or rehearing request is made. All right, so that's basically the tour of a life cycle of a hearing. If you have any questions about any of this process or any of the terms that I have gone over on this presentation, you can forward your question or request to the ACMS team, and that's acms@dss.ca.gov. You can also ask your supervisor. Your managers are very knowledgeable, and they will probably be able to guide you in the right direction. And remember, there are some small intricacies that are different depending on what type of case you're looking at, whether it's a general jurisdiction case, an ACA case, an IHSS case, scopes case. So all those little cases have different timelines and different rules and laws that govern them. So there might be some small differences between cases when it comes to this hearing process. All right, thank you for listening to this video and have a great day.